Okay. Okay. Is it 6 o'clock?
Oh, there's one attendee. Okay.
All right, let me just. Hello, good evening. My name is Yolanda Cruz with the City of Hayward Housing Division. Firstly, I'd like to thank everyone for participating in this workshop. Tonight's workshop is for Hayward's landlords. It's about COVID-19 related tenant protections and landlord relief. We have two presenters for tonight. Our first presenter is Emily Hislop with Project Sentinel, and the second presenter is Bronte Kinis. I'm sorry if I mispronounce your word, Bronte. And Bronte is with Central Legal de la Raza. We are going to have question and answers round after each presentation. So I give you now Emily with Project Sentinel. Thank you. Take it away, Emily.
Thank you, Yolanda. And hi, everyone. Thank you for coming. So just to review, I'm with Project Sentinel. We're a nonprofit housing services agency, and we serve many communities in Northern California. We have 3 core services, and one of those is neutral landlord and tenant counseling and dispute resolution, which includes supporting some cities like Hayward with administration of their rent stabilization program. We've also been very involved with the state's efforts and other counties' efforts in educating about rent relief programs related to COVID. We also have a HUD certified counseling branch that provides first-time home buyer mortgage foreclosure and pre-foreclosure and financial credit counseling. So I will emphasize this at other points in the presentation and while answering questions that we do not offer legal advice or legal representation, but we offer tips, best practices, and an overview of applicable local and state laws. For legal services, please contact an attorney or lawyer referral service, and we have some numbers for that at the end of the presentation. So what will we cover this evening? I'm going to go over the COVID-19 eviction protections at the state and local level. And then I'm going to turn it over to Central Legal, who's going to present about the county-run rent relief program that's, I believe, both tenants and landlords can initiate applications for. Then I will briefly go over some of the small landlord mortgage relief options that were in state legislation enacted at the end of last year. and what that might mean for you if you're an impacted small landlord, and then also list out some resources. So after each section, we'll take some questions that come up, including questions that may have been sent before. So very quickly, there's statewide eviction protections. Back at the end of the summer, the state legislature sought to keep people housed, avoid massive homelessness, and protect the public from COVID-19. And on August 30th, they enacted the Tenant, Homeowner, and Small Landlord Relief Act of 2020, AB 3088. And this went mostly in place of all the local moratoriums that were passed by different states and counties since March of last year. In end of January this year, the legislature acted again to extend the protections and also expand into rent relief with SB 91, and that became law in January 29th and extended the eviction protections through the end of June. So very basically, with the COVID-19 eviction protections, unpaid rent from residential tenants, I should clarify that this is covering residential tenancies. I don't think I made that clear in the title. So everything that we talk about today will apply to residential tenancies, not commercial. So unpaid rent that accrued for tenants between March 4th, 2020 and June 30th of this year. And these tenants, the unpaid rent was due to COVID-19 related financial hardship. This unpaid rent can never be the basis for an eviction of that tenant. Any unpaid rent during that time for these impacted tenants. To make sure that the tenants have these protections, they would sign and return a declaration of COVID-19 related financial distress that they will return to their landlord. We'll cover this a little more detail about what that is. And also to ensure protection for rent that came due between September of last year and June 30th of this year. They need to have paid by the end of June at least 25% of that total rent for those months. So if they've paid all but a couple months since September, they've met that burden. So the declaration form, that is how the tenant will show that they are financially impacted. They sign it under penalty of perjury. It's something that is supposed to be provided by the landlord with any notice to pay or quit. So these protections protect all residential tenants, including mobile home tenants, regardless of their immigration status or if there's a written lease or contract. The unpaid rent is not forgiven. And until June 30th, just cause for eviction protections are extended to all residential tenancies. The Hayward just cause protections that are in Hayward's RSO still apply, but until June 30th, there are some further limitations that are imposed by the state law. And so this means that under very limited circumstances, a tenancy can be terminated only if there is a legally valid reason and that is stated on the termination notice. Also, these eviction protections, well, I outlined what they need to do, the tenants with unpaid rent, to be protected. Landlords have a requirement to serve certain documents to comply with the law and to reserve their rights. Tenants, like I said, they will still owe any unpaid rent that isn't covered or waived by rent relief. But collection actions on that rent cannot be started until August 1st, and those can be initiated in small claims court, but the landlords will have to fill out extra forms and answer questions to show that they've complied with the law and either sought or complied with a tenant seeking rent relief. Any landlords who refuse rent relief funds or do not make any attempts to apply on behalf of qualifying tenants, they could be barred from demanding or collecting the full amount from the tenant in court or otherwise. Some things about the COVID rent debt. No late fees can be charged on the rent that accrued during this time for affected tenants. In the future, if a tenant has COVID-19 rent debt on their credit report, that cannot be used as a negative factor when a landlord is screening a potential tenant. The rent debt cannot be sold or assigned if the tenant would have qualified under the state's rent relief program. So that is under 80% of AMI. For tenants that wouldn't have qualified for that rent, that debt can only be sold or assigned to like a collection agency after July 1st. But please keep in mind, if a tenant would have qualified for rent relief, whether or not it was applied for and received, that rent debt can't be sold to a collection agency. Rent payments, current rent payments, so if a tenant pays rent now, it's supposed to be applied to the prospective month's rent. So if you receive a rent check on April 29th, unless the tenant indicates otherwise in writing, that's going to be applied towards May's rent. A current tenant security deposit cannot be used to satisfy COVID rent debt. I will anticipate that the question will be asked if the tenant has moved out. There is nothing precluding the security deposit to be applied towards unpaid rent, but you still must follow security deposit rules and deduct for other allowable charges first before applying the unpaid rent. And any retaliation against tenants who have COVID-19 rent debt is barred under state and local laws and could be subject to strict penalties. To go a little bit over just cause protections, and we did get one question ahead of time that I can cover here. So all tenants are entitled to just cause protections until June 30th, 2021. Hayward tenants have pretty extensive just cause protections under the RRSO. But basically, this means for any at-fault cause where the tenant has done something wrong or breached a term of the lease, the landlord first has to give the tenant a notice so they can try to fix the problem, usually a notice to cure or notice to cease. Only if the tenant has not fixed the problem could they then go to the next step of termination. Now, this is the question that I have gotten about sale of a property. Now, the SB 91, AB 38, this state legislation specifically says that a tenant can only be terminated in a property that's going to be sold or is in contract if it's in contract for sale and the buyer intends to occupy the unit. So if you're just putting your house on the market or the building on the market, that is not a just cause for termination. If a person makes an offer, that offer is accepted, and they're in contract to buy the property, and that buyer intends to live there, then that is an allowable just cause. But it specifically states that it has to be in contract with somebody who intends to buy the property. Another allowable just cause where the tenant is not at fault is if there's an intent to demolish or substantially remodel the property, but only if, and the substantial remodel is only if the property is, only if the remodel is necessary to make the unit habitable. So any no cause evictions, like just a 30 or 60-day termination notice, those are not permitted against any tenant, whether or not they're covered by another just cause law, until after June 30th, 2021. So like I said before, this is in addition to current eviction protections under Hayward's local just cause ordinance. So I wanted to give a little picture of noticing, because this is a question I get from landlords about, some haven't given a notice. They understand the tenant hasn't been able to pay rent, but before they should give a notice under Code of Civil Procedures, Section 1179.04B. This notice basically tells the tenant of their rights. So this notice should be served on any tenant who has unpaid rent since March 4th of last year. This is going to tell them what they need to do, what protections they have, what they need to do to be protected. This notice was supposed to be served by the end of February. And if you haven't served it, I would just go ahead and serve it. And it has to be served before any notice to pay or quit. If a landlord is going to serve a 15-day notice to pay or quit for rent that's due now, it must have this some state language, and the state has these forms on their website in multiple languages. This 15-day notice to pay or quit will you will list out the months of rent that were unpaid, what rent was due, what rent was paid, and give an accounting of that. With any 15-day notice to pay or quit, and just a reminder, there's no 3-day notices to pay or quit right now. That's it. Any notice to pay has to be a 15-day notice. So any notice to pay also has to be served with a declaration of COVID-19 related financial distress. And I'll show you where to find this form. You must give the tenant an unsigned copy of this declaration and tell them, the best way for them to return it to you. I'll go over that on the next slide. If your tenant has unpaid rent between March 1st of last year and August 31st of last year, there's a different notice to pay or quit because that unpaid rent is treated a little differently. And if you're wanting to give your tenant notice of everything, you just need to be sure to use this form for anything unpaid from that time, plus an additional declaration form. If you're a landlord who's giving a 15-day notice each month that the tenant hasn't paid full rent, every time you have to give them a blank declaration form, and they have 15 business days to return the declaration. And I've put the link for where to find these forms, and I included little snapshots because there's a lot of forms listed, so you know which form you need to select. And then the tenant declaration are under the tenant forms. So like I said, any notice to pay or quit must be a 15-day notice, must contain specific information, and must be served with this declaration of COVID-19 related financial distress. These forms should be served in the language that the contract was negotiated with the tenant. And this declaration form is a single page. So if you know your tenant's primary language is something other than English, you could print it double-sided with their language on one side and English on the other. So like I said, all these forms are in 6 languages on the state's website. We also suggest that you instruct the tenant how to return it. Can they take a picture of it once they've signed it and text it to you? That's probably the easiest way for most tenants. But otherwise, if you don't specify, the tenant's they just have to give it in the same manner that they would pay rent or give notices. Also, I'll go over this on the next one, but this declaration, a tenant is signing under penalty of perjury that they have been impacted financially due to COVID-19 and that affected their ability to pay full rent. Signing something under declaration under penalty of perjury is considered evidence. So there's no further documentation that should be required from a tenant. They simply signing this and providing you, that's how they're demonstrating their need and their situation. There is a very narrow exception to this. If you know that your tenant makes over 130% of the area median income or over 100,000. I think for Alameda County, this is quite high. You can ask for additional financial documentation, but you have to have known that before. So you have to have some documentary proof that you knew the tenant household earned that much. And there's more information on that, on those forms about this. So this is a very narrow exception. For most tenants, you can't demand anything more than the signed declaration. So prohibited actions, just as a reminder, what might be considered retaliation or constructive eviction. It's illegal for a landlord to discriminate against a tenant based on age, race, religion, disability, source of income, primary language, immigration status, for example, to harass or retaliate against a tenant for missed rent. Other examples of retaliation can include a landlord telling a tenant or texting a tenant that they have to leave without going through the court process, any threats, locking a tenant out, cutting off any utilities, water, electricity, otherwise throwing personal property out on the curb. Other actions that are meant to intimidate or deceive can also be considered retaliation. And those fines have been increased for landlords who try to evict tenants outside of the court process during these COVID-19 eviction protections for tenants that have unpaid rent. The city of Hayward did have a temporary moratorium on evictions, and that expired in September of last year. There was a county eviction moratorium that was enacted last year. And to learn more about that, I've put the link there, and that set forth some payment periods. County courts, we are told, will implement the county ordinance. And for more information, you can go to the court's webpage. And people who are participating or attending this webinar should receive a PDF of these slides. So that was a lot. I may have not touched upon everything, but this is the state's website where the forms and a lot of useful information about the eviction protection and resources can be found. You can go to housingiskey.com or housing.ca.gov. They are updating this website all the time. It's available, a lot of the information is available in multiple languages. Do we have any questions at this time, Yolanda? Can't tell if anyone's raising their hands. I'll see. Oh, I see. I think, let's see. There was one question that may be from this person, and you can put your hand down. There was one question ahead of time about an ADU in unincorporated Alameda County. If it's truly an ADU, so the person's question had to do with just cause protections if there is for an accessory dwelling unit, but it's a property that's outside of Hayward.
Yes.
So, yeah, go ahead.
I'm a landlord in unincorporated Alameda County, and I own a property which has an ADU.
Mm-hmm.
I want to move back into my ADU, and it's my understanding that it's just cause under my exemption of AB 1482. I believe another way to get back my ADU is to take it off the market under the Ellis Act, which is the most efficient way to take back my ADU. My tenant have gotten along for 5 years, but I want to take back my ADU.
So, I'm sorry you're having a difficult situation. So what law covers that depends on if you live.
I don't want to buy her out.
So I can tell you what laws may apply. I can't give legal advice. Do you live in the main house?
Yes.
If you live in the main house, that is truly an accessory dwelling unit, and you are not covered. Are there any other units on the property?
No.
Then it would be exempt from AB 1482.
Yes.
There is just cause protections until June 30th. And unless they are extended at that point, you could give them a 60-day notice, no cause termination. There is not any, if it's truly an accessory dwelling unit and you live in the main house, it's exempt from AB 1482.
It truly is. When the other laws that were enacted after that overturned my exemption to AB 1482?
I mean, to get a concrete answer, I would either call the Rental Housing Association or an attorney to get a better idea. But from the facts you're telling me, that would likely be exempt from AB 1482. But it is covered by the temporary COVID-19 eviction protections because all tenancies are. But those are only until June 30th of this year.
Okay, thank you.
Okay, are there any questions about the eviction protections or noticing? Because I will turn it over to, I believe Monique Berlanga from Central Legal will go over the county's rent relief program. If you're.
Yes, hi, I'm here. Thank you, Emily.
Okay, so I'm gonna stop sharing. Are you able to share slides or do you need me to share the ones that were sent?
I can share them.
Okay.
Thanks. Apologies. Okay, great. Can you see the screen? Hope so. Okay, my name is Monique Berlanga. I'm the directing attorney of the tenants' rights practice at Centro Legal in Oakland. And we are working with the County of Alameda to administer the county's rental assistance program right now. So I will give you some basic information in terms of who's eligible to apply, what the application process looks like, what documentation you'll need, and then what the process is after you apply. And then I'm happy to answer any questions. Okay, so to give you an overview of the program, so the Alameda County Housing Secure Emergency Rental Assistance Program is intended to help income eligible households pay rent and utilities, both for past due and future rent payments. We are in phase 1 of the program, which launched on March 17th, 2021. Phase 1 of the program prioritizes 3 different categories. The first being tenant households who make less than 30% of the area median income, so extremely low income households. Second being small rental property owners who own 5 units or less. And the third being tenants in subsidized affordable housing. These priorities will be expanded in phase 2. The main distinction between phase 1 and phase 2 functionally is that in phase 1, the program can pay 100% of back rent and utilities arrears. Once we transition into phase 2, which we anticipate will happen in early June, the program will only be able to pay 80% of back rent owed by tenants, and only if the landlord agrees to waive 20% of the back rent owed. So we're really encouraging small rental property owners to apply as soon as possible to initiate the application, so that way you can avail yourself of that benefit of getting 100% of the back rent. So again, here we're restating the phase 1 program priorities: very low income tenants, 30% AMI or less, small landlords who own fewer than 5 units, and tenants in subsidized affordable housing. Eligible use of funds. So what can the rental assistance funds be used for? Rent arrears, of course. The program may pay up to 100% of rental arrears accrued after March 13, 2020, as funding availability allows. The program can pay up to 12 months of rental arrears, and the program can pay for utility and home energy costs that are covered by the landlord, and those will be treated as rent. If the utilities are separately stated, and they're not paid directly to the property owner, then the tenant can still apply for utility arrears payments, but those payments will be made directly to the utility provider. Program eligibility. So who is eligible? So the tenancy must be in Alameda County, excluding Oakland and Fremont, who are running their own local programs, and I believe Oakland is also participating in the state program as well. So all Alameda County, not including Oakland and Fremont. The tenant must have experienced a COVID-19 related hardship. Either they've qualified for unemployment benefits, or they've had reduced income, or incurred significant cost, or experienced other financial hardship due to COVID-19. The tenant must be at risk of homelessness or housing instability, which can be demonstrated by being behind on rent or utilities, or living with habitability issues, or a number of other methods. But this will typically be demonstrated by being behind on rent. And to be eligible, the tenant's household income has to be at or below 80% of the area median income. Okay, so are you eligible to apply? So few questions to ask. Are you the property owner who has legal authority to lease the unit? Yes. Do you have 1 or more eligible tenants with unpaid rent between March 13, 2020 and today? Sorry, this is a little outdated. This was drafted in March due to a COVID-19 related event. And do you have a tenant lease or written agreement with the eligible tenant? If so, we encourage you to visit ac-housingsecure.org and fill out an application. What documentation will you need? So if you think you're eligible to apply, we encourage you to apply. You'll need the following documents. So we will require a W-9 form in order to issue the payment, because all payments will be made directly to the property owner. We will need verification of the residency, which can be a lease agreement. Typically, what the property owner will have is a lease agreement, which will really expedite the process if you can provide that. Otherwise, we will have to try to get that from the tenant, and that could take longer. We'll need verification of ownership, so a property deed, a mortgage note, a property tax form, homeowner insurance form, some type of documentation that shows that you are the owner of this property and are entitled to collect rent. And then again, a current lease signed by the applicant that identifies the unit where the applicant resides and establishes the rental payment amount. We need something showing not only that the tenant has a tenancy there, but what the regular monthly rental amount is. And in addition, a ledger or other accounting of the back rent would be really helpful in expediting applications as well. So what is the application process? So at ac-housingsecure.org, there's 2 buttons. One says tenant assistance, one says landlord assistance. If a property owner wants to apply, they can click on that button and initiate the application process. Again, there are some required fields, but I believe you can submit the application without uploading all of the required documents. However, it will expedite the process if you have all the documents attached to the application when you do submit it. So once the application is submitted, if it's a landlord initiated application, Centro Legal will screen for geographic eligibility and convert, and so long as it's geographically eligible and you have verified that you're a small property owner and are therefore eligible in phase 1 of the application process, then we will assign your application to one of our tenant application assistance partners. And right now we are working with 3 different agencies: Bay Area Legal Aid, Eden United Church of Christ, and the Eviction Defense Center. So their staff right now are working hard to process applications. So one of those agencies would contact you and contact the tenant to obtain any missing information and documents. They would conduct a primary review and verify the documents, and then they will submit that application back to Centro Legal, where we will conduct a secondary review and verification. And as long as everything is there, we will issue the payment directly to the owner or to the utility provider. This is just a screenshot of what the web application looks like. You can start it and click the button that says save my progress and resume later. Again, you can submit an incomplete form. However, I would really encourage you, given the volume of applications we're receiving, to submit as complete a form as possible. The more documentation you can provide us, the less we have to try to obtain from the tenant. Oftentimes our low-income tenants that we are working with have significant barriers in terms of access to technology, language access, etc. So the more you can streamline the process, the quicker we can get payments out the door. So again, this is the website to visit, www.ac-housingsecure.org. A couple other logistical things to mention. This program is anticipated to run through the end of the year, so there's not a deadline to submit an application. We're asked a lot what's the amount of funding available. The initial amount of funding is $26 million available for tenants throughout the county. We anticipate that another $30 million will be available in phase 2. So there's a lot more money available than there have been in past iterations of rental assistance programs in Alameda County, and we anticipate that this program will last longer. Therefore, we are encouraging folks to do their best to gather all of the documentation before they apply in order to expedite the applications. So I'm happy to answer any questions that folks have. And while I do that, I'll leave the contact information up here, our contact information at this point.
Hey, Monique, Robert Robledo with Rental Housing Association. Thank you to you and Emily for providing this awesome webinar. I do have 2 questions for you. A lot of my members are asking, they've submitted applications, so how much longer do they need to wait right now in the process? That's
a great question. Yeah, so in phase 1, Centro Legal's role is the back-end administrator. We are not processing applications. The county is working right now on contracting additional tenant application assistance agencies. Right now, there's 5 staff amongst the 3 agencies I mentioned who are processing all of the applications. We've received 2,700 to date. So there's just not enough staffing yet. We are hopeful by the end of May that the county will have contracted with additional staff to get the applications processed faster. So I'll say that the first round of checks went out this week. The program is ramping up. We hope to be at a level of processing at least 100 a week by the next 1 to 2 weeks. However, it really is just a staffing and capacity issue, and it's, it's going slower than we would like at this point, but once the county is fully staffed up, we hope that things will move quicker.
Awesome, awesome. And then my last question, some of our members are asking, do the tenants need to sign off on anything in order to expedite the process? And thank you again for both answers.
Yes. So that's a very, very good question. So, like I said, the landlord can initiate the application, and then what will happen is it'll go into the queue, it'll get assigned out, then the processor will have to contact the tenant, because we do need, the tenant's income verification, hardship declaration, identification, etc. If you have a tenant, so the application assistance processors can do that legwork. If you are able to encourage your tenant to apply on their own through the tenant application, then both of your applications will be matched together in the back end. And then once they're assigned to the processor, they will be packaged with a bow and everything will be there already, and it'll really streamline the process. So yes, absolutely. If you have already applied or you intend to apply, we do highly encourage you to ask your tenant to also apply to streamline the process.
Awesome. Thank you so much, Monique. Appreciate it.
Monique, you're still muted, so I don't know if you were asking if there were any other questions.
Oh, no, nope. I guess I'll stop sharing now. I can see. If there are any other questions, happy to answer. If not, I can sign up.
It looks like there's a question in the Q&A.
Oh, okay. Sorry. Are prospective rent and utilities covered in phases 1 and 2? Yes, they are. So the program can pay up to 3 months of prospective rent and utilities in phase 1 and phase 2. However, we can only pay, prospective rent is contingent upon how many months of back rent we're paying, right? So there's a cap of 12 months total. So if we're paying 12 months back rent, then we're probably not going to be able to pay 3 months of prospective rent. If we're paying 3 months of back rent, for instance, then we can pay up to 3 additional months of prospective rent or utilities. And then the second question, what happens if the landlord does not participate? Can tenants still obtain 100% back rent in phase 1? Yes. Are tenants or landlords required to have a lease or rental agreement? So the tenant, we have to verify that that there is an obligation to pay rent on a residential dwelling, whether that's a written lease or an oral lease, doesn't matter. That can be proved with an attestation, a declaration from the landlord saying, yes, this is my tenant, this is how much they pay every month in rent. There's not a requirement that there is a written lease. It's preferable that we have a copy of a written lease. However, we do understand that lots of folks do not have written leases, and we can work with that. Can other documentation such as bank statements establishing the pattern of paying rent substitute? Yes, absolutely. Again, the most efficient way to get the application processed is going to be, giving us a lease and a ledger and packaging it up with a bow to make it very easy for us to process the application. If those things are not available, then we are able to have tenants or landlords self-certify many of the elements that need to be proven. Okay. Okay, well, there's another question. Will there be any assistance for back rent from April through June? Yes. So the program can cover rent after March of last year through the end of the program, which is anticipated to run through the end of this year. So yes, if a tenant it couldn't pay April rent, then a landlord or tenant can initiate an application for this rent, for that rent. Similarly, we have a lot of questions from tenants who are saying, okay, I've been able to pay, I've depleted my savings, I've borrowed, and I paid all my rent, but I can't pay next month's rent. Am I out of luck? And the answer is no. The tenant should still apply because we can pay prospective rent to allow tenants to, get caught up on any other debts that they may have accrued in an effort to pay rent above other things.
I apologize. Do you have a question if I pronounced your name wrong?
Yes, ma'am, I do. So my question is, how long does the process take from submitting the application to the funds actually being dispersed to either the tenant or the landlord?
Yeah, again, great question. And I think it will depend on whether you are eligible for phase 1 or phase 2. If you're eligible for phase 2, but not 1, and you apply now, then your application, will be on hold until phase 2. If you are eligible for phase 1, then, like I said, it's really just a staffing issue as the program continues to get staffed up as to how quickly we can process individual applications. So, again, I can't give you an exact time estimate, but I can say that the more complete the application is, the quicker we'll be able to process it.
Got it. But given if there is a missing document or an error, you guys will reach out to either the tenant or the landlord to request the updated information. It's not like an automatic denial.
Absolutely. Yes. And so really that's the delay is how many folks we have staff available to reach out to folks to obtain the missing documentation. And something else I would suggest is if you submit the application and you find it's incomplete, you can always contact us and supplement your application with the additional documentation while you're waiting. Or like I said, having the tenant also apply simultaneously will also expedite the process.
Oh, really? How do we contact you guys? I don't see a phone number or a way to track the status of the application.
Yeah, so that's a good question. So when you do apply, you'll receive a confirmation email that will give you some details, and then it'll have an email address to check up on your application. The phone number for because there are many organizations who are partnering to administer this program, and there will be additional organizations added on, the central number to contact us is 211, who they are contracted with the county to kind of be the central phone number, for the program. So any questions, concerns, or if you know of a small property owner who does not have any access to technology and needs assistance actually filling out the application, they should contact 211.
Okay, got it. Thank you so much.
And then I'm seeing another question. Do all leaseholders have to apply in order for the application to get approved? No. So one leaseholder can initiate the application. However, we will have to obtain information about all of the household members in terms of identification and income, proof of income, because we will have to add up all the income from all household members and make sure that in total, the household is 80% AMI or lower for their gross income. Any more questions? Last chance. Great, thank you very much.
All right, so is there anything else, Emily or Monique, you want to add?
I can go over the small landlord mortgage relief options and the resources, but if anybody has any further questions about rent relief, while we have Monique here. Otherwise, we thank you very much, Monique. That was very helpful. Oh, there's something in there. So I'm gonna move on, and again, thank you so much, Monique. That was great. And I hope that sounded like a lot of useful information and questions were answered. Okay, so I'll briefly go over the small landlord relief portion of the state legislation. So back in September with AB 3088, the state legislature also tried to include as much as they could, because much banking regulations are at the federal level. So what they define as a small landlord in the law is an owner of 4 or fewer properties, and each property has no more than 4 rental units. So you can have a duplex and 3 houses that you all rent out on, or 4 fourplexes, and you would be considered a small landlord. The properties do not have to be owner occupied. And to be COVID impacted just means you have at least one tenant who has not paid full rent since March of last year. And what that might make you eligible for is some mortgage relief options. So there's sort of 3 things that you might be able to work out with your lender: either forbearance, which is a temporary suspension or reduction of the mortgage payment for a specific period of time, and until you can get access to rent relief funds or start accruing more rent after the people are going back to work and paying rent. You can see if you might be able to work out a mortgage modification where there's a permanent change of 1 or more of your existing mortgage terms, or possibly work out a repayment plan, like a 6 to 12 month plan to repay the past due amount. So we have had certified housing counselors at Project Sentinel, and if you think that they can give you advice or help you work with your lender to try to get one of these options if you are struggling with mortgage payments and have a COVID impacted tenant who hasn't paid full rent. So I linked to our website here. The number for our head counseling division is 408-470-3730. They're very knowledgeable and have been working with lenders since after the 2008 mortgage foreclosure crisis. So they have a lot of expertise in this area and can help. And they've received grants from the government to try and help small landlords and homeowners during this crisis right now. And then my last slide, and everybody should get a copy of these slides. We've put in a bunch of information. So for information about Hayward's rent stabilization ordinance and just cause and other housing issues, there's the hayward-ca.gov website, housing division. They also, on their website, have a list of legal resources. For mediation services, fair housing questions, working with your tenants on other issues, you can go use echofairhousing.org. Now, like I said before, and I think I've linked to the wrong thing there, but on the state's housingiskey.com website, I would recommend all landlords click on the publications icon at the top, because there is an excellent guide, Landlord and Tenant Responsibilities guide, that's linked so you can go chapter by chapter. So if you have any questions about the landlord-tenant relationship in plain English, they've revised their guide. So just questions about security deposits, renting to tenants, all those sorts of things. So I encourage landlords to go visit this website and see how many resources and things are on there, and to visit it when they have questions. I put our head counseling number again here. Also, in addition to the state's website, if you own a few properties, we highly recommend the Nolo Press California Landlords Law Book. They have articles, they have forms, templates, and really just kind of common sense best practices material in there about being a California landlord. There's also the Superior Court self-help website, has a lot of useful information about what unlawful detainer to eviction court or small claims proceedings is like. If we encourage people to try to work out any repayment or tenancy issues outside of the court process, but if you need to learn more about that, that's another resource. So I can stop here, and if you have any questions, even going back to the eviction protections, I'm happy to try and answer them or address them. I think Heva Vreg has her hand up again.
Yes, I do. And thank you for your patience. So I did send an email with a question. I think I might have dropped and rejoined when you answered the question about a landlord wanting to sell the
Right.
property with a tenant in it.
Okay, so that was, I'm just going to go back to that slide. Oops, did I already pass it? Yes. So under the COVID-19, under SB 91 and 3088, it's very specific that if you're just going to sell the property, that doesn't fall under just cause. It says that if the property is in contract with a buyer who intends to occupy it, at that point the tenancy can be terminated. If it is a Hayward unit, it's also covered by the Hayward just cause laws, and just simply selling the property is not listed as a just cause.
Got it. Perfect. One more question. Is this session recorded and the slides will be emailed to the participants?
Yes, Yolanda, can you make sure that I sent the PDF of the slides so they could be emailed?
Perfect.
Yes.
There's a lot of information and I wanna have it for later. Thank you guys so much.
Okay, thanks. So Hiva, if you have an email address, please email so I can send them to you, or probably we can just make this available on the website for everyone. So those participants who wanted to view the slides, we will have, we'll request for the slides to be posted on the website.
Which website?
The Hayward website, hayward-ca.gov.
Got it.
All right, thank you.
You need to end the slideshow. Sorry about that. So there were two questions. I want to pull up my slides again. That was an accident. So one of the questions is about an organization that that serves Castro Valley, I believe, echohousing.org, which was on the resources that they offered tenant landlord counseling. We don't have a contract to serve Castro Valley at this time. Go and then, sorry, I'm being challenged technologically here. Now there's no question. So, okay, do you guys see the screen with the, oh, shoot, oh well, you can see it though. So the other question was, can landlords issue a 90-day notice of non-renewal at this time? A lot depends on if you are covered otherwise by just cause protections, either under AB 1482 or the Hayward law. I would consult an attorney or the Rental Housing Association to find out what laws may apply to your unit. And I cannot tell you if a termination notice issued now that may call for termination after the June 30th. I can't tell you if that's legally enforceable or not. But we encourage people, if you truly would be able to terminate the tenancy after the temporary protections are lifted, that you work with your tenants and try to give them as much time as possible if you aren't covered by any just cause or relocation assistance rules. Any other questions?
It's based on what you just said. So for the sale of the property after June 30th, what you mentioned, that the just cause evictions, or I should call eviction, just like the moving out of the tenant, that would expire. So basically the landlord will be able to ask the tenant to move out so that they can sell, or would that still have effect after June 30th to not have the tenant move out unless the new owner on contract is moving in as a owner occupant. Does that make sense?
Yeah, so after June 30th, what depends is if this property's in Hayward, if it's covered by the Hayward just cause ordinance, you would have to have one of the allowable just causes, and you can visit the website or call the housing division number to find out if you're covered. If it's not covered by, it just would have to fall under one of those. It's just this law was very specific about the property being in contract to a buyer who is going to live there.
I understand, and that would apply even after June 30th.
So that's a temporary protection that covers all tenancies until June 30th. After June 30th, you have to look at whether you're covered by Hayward's just cause laws, which I didn't cover in this presentation, and I just can't answer that question off the top of my head. But I would encourage you to call and or visit there's lots of information on the website. Or if it's not covered by Hayward's, which I think most properties and rental properties in Hayward are, if it's covered by the state just cause protections. But is your property in Hayward?
So I think I'm a tenant, and I'm in the wrong place, but there's a lot of information that I learned. So
I see.
Yeah, that's why I'm asking. But it is in Hayward, yes. I live in Hayward.
So if you can contact the housing division and learn a little bit more about and go to the website. I apologize. I don't know the rules around that type of situation. You're protected now until June 30th.
Okay, got it. Thank you so much.
Yolanda, do you see, will you be able to get an email list from IT of who registered and you could send them the slides? Or should people put their email in the?
I may be able to, but if they're interested, just to make sure, they can send an email to the housing division. It says here, the information is under the very top, Hayward, housing at Hayward, and just send an email requesting for a copy of the slides. But I will work with IT to make sure the slides are posted on the website. I will request them.
I'm gonna put this, type the email. Okay, copy. So I also typed the email into the Q&A.
Okay.
Oh, one more time.
Any other questions? Emily, anything else you want to add?
Well, thank you all for coming and your helpful questions. Hope we could address everything.
Thank you all very much. In that case, if there's no other questions, thank you all. Thank you all for participating. Thank you, Emily. Thanks, Monique. And in that case, good night, everyone. And thank you all very much. Thank you. Take care.